Kiskiplanter-news, July 2013.
And the Justin Amash amendment revoking that authority by the NSA. On the NSA, the leaker of that information, Edward Snowden, is still in Russia, with the Obama administration today telling Russia that he should be returned to the United States to face espionage charges. The Associated Press writes that a state news agency in Russia said today that Mr. Snowden had been given a document allowing him to leave the transit zone of a Moscow airport, but Snowden's lawyer later said his asylum status hasn't been resolved and that the National Security Agency leaker will stay at the airport for now. So debate on the NSA next up in the House.
Yeas are 199 in House Report 113-170. For what purpose does the gentleman from Kansas?
I rise as the designee of Mr. Nugent to offer the Nugent Amendment.
The committee will be in order to
that Mr. Snowden illegally exposed while sitting in a hotel room in communist China. First, the amendment clarifies that under Section 702, no U.S. citizen or person in the U.S. can be targeted, period. I say again, no U.S. person under Section 702 may be targeted in any way by the United States government. While there are other specific authorities, a U.S. person may be subject to an investigation. The U.S. government may not do so under Section 702. And that's this amendment intends to clarify. The second part of the amendment clarifies Section 215, also known as Section 501 of FISA. The amendment clarifies that no content of communications can be stored or collected by the National Security Agency. That's no emails, no video clips, no Skype, no record of the actual conversation or the contents thereof may be recorded or collected by the National Security Agency. I can't repeat that enough. That's the intent of this amendment. I want to make clear to everyone that contrary to the suggestions of some, the NSA has not been acting outside of the scope of its authorities. The metadata program is carefully designed with program layers of oversight by all three branches of government. This is precisely the way our government ought to operate, with input from Article 1 and Article 2 and Article 3 of the United States Constitution. It's, of course, our duty to ensure that the NSA stays within these legal bounds here in Congress, and this amendment makes those boundaries perfectly clear for everyone to know and understand. And we shouldn't mislead the American people into thinking that the NSA has been acting illegally. There is perhaps no program in the United States government that is as carefully monitored and overseen as the programs this amendment attempts to clarify. To the extent that some in this chamber wish to review or provide more protections and controls for these programs, we should proceed through a carefully considered and debated legislative process so that the full implications for our security are clearly understood. Mr. Chairman, I reserve the balance of my time.
Is the gentleman...
I am not opposed to the amendment.
Does the gentleman from New York see? No.
I claim time in opposition.
I had a feeling. The gentleman from gentleman from Indiana is recognized to claim the time in opposition. You control 7.5.
I recognize the gentleman from New York for 1.5 minutes.
Gentleman from New York is recognized for 1.5 minutes.
Thank you, Mr. Chairman. This amendment has been described and offered as an alternative to the Amash amendment that we will consider next. It is not. This amendment restates the existing ban on the intentional targeting of United States persons under Section 702. It also places into law for the next fiscal year the Obama administration's current ban on collecting the contents of the communications of U.S. persons under Section 715. I agree with these prohibitions, but they have nothing to do with the current misuse of Section 215 to engage in the suspicionless bulk collection of Americans' telephone records. The dragnet collection under Section 215's telephone metadata program reveals call information, including all numbers dialed, all incoming phone numbers, and call duration, but not the content of communications. Therefore, this amendment would have no impact whatsoever on this misuse of Section 215. Metadata reveals highly personal and sensitive information, including, for example, when and how often one calls the doctor, a journalist, or the local Tea Party or ACLU affiliate. By tracing the pattern of calls, the government can paint a detailed picture of anyone's personal, professional, and political associations and activities. Congress never authorized this type of unchecked sweeping surveillance of our citizens, and it is this problem, the indiscriminate bulk collection of metadata under Section 215, that we need to fix right now. The Amash-Kanyes Amendment does so by restoring the required reasonable relationship between the collection of records and specific persons being investigated under Section 215. The Amash-Kanyes Amendment ensures that this standard is not ignored by the administrator or by the FISA court as is happening now. This amendment does not fix the problem with 215. The Amash-Kanyes Amendment does. However you vote on this amendment, and I intend to vote in favor of it, it is imperative that we also vote in favor of the Amash-Kanyes Amendment, because this amendment, although doing no harm, does not solve the problems that Congressman Sensenbrenner and many others have articulated with respect to the misuse of Section 215 of the Patriot Act. Thank you. I yield back.
Gentlemen, we're reserved for yielding, and I think the gentleman from Kansas focus on what concerns most Americans, and it clarifies what really is and is not happening. Sometimes it's a challenge for those of us on the Intelligence Committee to talk openly about this, even the safeguards in some of these programs. But this amendment helps make it clear and reassures Americans about some of the things they may have read or heard that is occurring with NSA. But at the same time, this amendment is not an overreaction that actually increases the danger that Americans face from terrorism around the world. This amendment says clearly NSA cannot acquire information for the purpose of targeting Americans, and it says clearly that NSA may not acquire, monitor, or store the content of the communication of any Americans. And I think the key point that members need to know is there are multiple layers of safeguards to make sure that these programs operate exactly in the way that the FISA court has laid them out to operate. The intelligence
Security and must coexist together. This amendment states that in no uncertain terms that the government cannot use Section 702 of the Foreign Intelligence Surveillance Act, FISA, to intentionally target an American for surveillance. This important amendment also reaffirms that the phone conversations cannot be collected through Section 215 of the Patriot Act. It makes the intentions of Congress very clear. I believe the party has helped prevent terrorist attacks on U.S. soil. A planned attack on the New York City subway system was stopped because of Section 215. But the Amash Amendment passes this authority, and it will end it. This amendment goes too far, too fast, on the wrong legislative vehicle. We need to debate the scope of this program, and we are. But this is an extreme knee-jerk reaction to the situation. This program has been authorized and reauthorized by Congress. It receives extensive oversight by the intelligence,
which requires that there be relevance to a terrorist investigation. I do think that I certainly do not challenge the motivation of the gentleman who has offered this amendment.
Number 100, printed in House Report 113-170, and for what purpose does the gentleman from Michigan seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 100, printed in House Report number 113-170, offered by Mr. Amash of Michigan.
Pursuant to House Resolution 312, the gentleman from Michigan, Mr. Amash, and a member opposed will each control 7.5 minutes. Chair recognizes the
Chairman, I yield myself 1 minute.
Gentleman is recognized for 1 minute.
We're here today for a very simple reason: to defend the Fourth Amendment, to defend the privacy of each and every American. As the Director of National Intelligence has made clear, the government collects the phone records without suspicion of every single American in the United States. My amendment makes a simple but important change. It limits the government's collection of those records, to those records that pertain to a person who is the subject of an investigation pursuant to Section 215. Opponents of this amendment will use the same tactic that every government throughout history has used to justify its violation of rights: fear. They'll tell you that the government must violate the rights of the American people to protect us against those who hate our freedoms. They'll tell you there's no expectation of privacy in documents that are stored with a third party. Tell that to the American people. Tell that to our constituents back home. We're here to answer one question for the people we represent. Do we oppose the suspicionless collection of every American's phone records?
The gentleman's time has expired. The gentleman reserves. Who seeks?
Charge to claim the time of opposition.
The gentleman is recognized for 7.5 minutes.
Happy to yield 3 minutes to the gentleman, Mr. Rogers.
The gentleman from Michigan is recognized.
Thank you, Madam Chairman. I think the American people, certainly some well-intentioned members in this chamber, have legitimate concerns. They should be addressed. We should have time and education on what actually happens in the particular program of which we speak. And I'll pledge to each one of you today and give you my word that this fall, when we do the Intel authorization bill, we will work to find additional privacy protections with this program that has no emails, no phone calls, no names, and no addresses. 14 federal judges have said, yes, this comports with the Constitution. 800 cases around between the 1979 case have affirmed the underpinnings of the legality of this case. 800. So 14 judges are wrong, and 800 different cases are wrong. The legislators on both intelligence committees, Republicans and Democrats, are all wrong. Why is it that people of both parties came together and looked at this program at a time when our nation is under siege by those individuals who want to bring violence to the shores of the United States? Because those who know it best support the program, because we spend as much time on this to get it right, to make sure the oversight is right. No other program has the legislature, the judicial branch, and the executive branch doing oversight of a program like this. If we had this in the other agencies, we would not have problems. And think about who we are in this body. Have 12 years gone by and our memories faded so badly we forgot what happened on September 11th? This bill turns off a very specific program. It doesn't stop so-called spying and other things that this has been alleged to do, because that's not what's happening. It's not a surveillance bill. It's not monitoring. It doesn't do any of those things. What happened after September 11th that we didn't know on September 10th, and again, passing this amendment takes us back to September 10th. And afterward we said, wow, there is a seam, a gap. Somebody leading up to the September 11th attacks, a terrorist overseas called a terrorist living amongst us in the United States. And we missed it because we didn't have this capability. What if we had caught it? But the good news is we don't have to what if. It's not theoretical. 54 times this and the other program stopped and thwarted terrorist attacks both here and in Europe, saving real lives. This isn't a game. This is real. It will have a real consequence. This is hard. Think of the people who came here before us in this great body. Madison, Lincoln, Kennedy served here. And the issues they dealt with, and the politics of big and moving America forward, while upholding the Article 1 mandate to this House that we must provide for the general defense of the United States. And think of those challenges. Think of those challenges that they met. Are we so small to tell authorization bill?
Expired. The gentleman from Florida reserves.
I yield 60 seconds to the gentleman from Michigan.
The gentleman for amendment will not stop the proper use of the Patriot Act and FISA authorities to conduct terrorism and intelligence investigations. I'd never block that. All this amendment is intended to do is to curtail the ongoing dragnet collection and storage of the personal records of innocent Americans. It does not defund the NSA, and it would continue to allow them to conduct full-fledged surveillance as long as it relates to an actual investigation. Our joining together on this bipartisan amendment demonstrates our joint commitment to ensuring that our fight against terrorism and espionage follows the rule of law and the clear intent of the statutes passed by this Congress. I urge my colleagues on both sides of the aisle to vote for this amendment.
Gentleman, 2.5 minutes.
thank the Speaker. Thank you, Madam Speaker. This is a very important issue that we're taking up today because the number one duty of the federal government is the safety of the American people, of our constituents, and of our own skins, for each one of us who are in this chamber today. As we know all too well, national security is a real and present danger and something that we have to take quite seriously. We can't deal in false narratives. And a false narrative has emerged that the federal government is taking in the content of Americans' phone calls. It's not true. It's not happening. A false narrative has emerged that the federal government is taking in the content of the American people's emails. It's not true. It's not happening. We need to deal in facts, and the facts are real, and the facts are these. The only people who have benefited from the revelation of classified information by someone who worked for this government, who intentionally and unauthorized declassified some of the most sensitive national security information that we have. The only result is that those who are engaged in Islamic jihad will have been benefited, and those that we seek to protect have not. Consider this. There is more information contained in the phone book that sits at home on your kitchen counter about each one of us than the information that is in the national security database that we're talking about today. Your name, your address is in the phone book. Your name, your address is not in this national security database. No other nation in the world has the advantage that the United States of America has on national security. No other nation. And we, by this amendment today, would agree to handcuff ourselves and our allies by restricting ourselves. Let it not be. Let us not deal in false narratives. Let us deal in facts that will keep the American people safe. When you look at an envelope, when a letter is put in the mail, is there a privacy right as to what's been written on that envelope? No, there isn't. Where there is a privacy right is what's contained inside that envelope. That's a Fourth Amendment right. Is there a Fourth Amendment right to the record that you called someone on a certain day? No, there isn't. That's a record. But there is a Fourth Amendment right to what's in that phone call. Let's deal in reality, not in false narratives. And I yield back.
Gentlelady's time has expired. The gentleman from
Of the Amash Amendment. And I do so as the person who is the principal author of the Patriot Act in 2001, who got that law through quickly after 9/11, and who supported and managed the 2006 reauthorization. Let me make this perfectly clear, that unlike what we've heard from speakers on the other side of this issue, this amendment does not stop the collection of data under Section 215 to people who are subject to an investigation of an authorized terrorist plot. What it does do is prevent the collection of people who are not subject to an investigation. Now, relevance is required in any type of a grand jury subpoena or a criminal a collection of data for a criminal trial. This goes far beyond that and what the NSA is doing. The time has come to stop it, and the way we stop it is to approve this amendment.
Gentleman's time has expired.
This program have broad and far-reaching consequences. Many Americans feel that our fundamental liberties as a country and our constitutional rights is threatened. In addition, it has ruined and hurt our reputation abroad, threatening our trade relationships with allies, threatening American jobs as a result, and putting us in danger our cooperative security relationships that we need to fight the war on terror. The responsible thing to do is show some contrition. Let's pass this amendment. Let's make sure that we can have a practical approach that show that protecting our liberties and securities are consistent and critical for the United States of America. I urge a yes vote, and I yield back to saying
privacy versus security. It's a question beyond that. It's a question of who will do the balancing. Right now, the balancing is being done by people we do not know, by people we do not elect, and in large part right now by somebody who has admitted lying to this body in a hearing. That's wrong. We should be doing the balancing. We were elected to do that, and we need to pass this amendment so that we can do the balancing, not folks that are not elected who we do not know.
The gentleman yields back. The gentlelady from California is recognized for 30 seconds.
I want to talk about the much ballyhooed oversight. Every year there is a report to the Judiciary Committee, an annual report on Section 215. This year the report was 8 sentences, less than a full page. To think that the Congress has substantial oversight of this program is simply incorrect. I cannot match Mr. Sensenbrenner's brilliant remarks, but I do agree that when we wrote the Patriot Act, Relevance had a meeting, and I would ask unanimous consent to place in the record a letter to Mr. Sensenbrenner from the Department of Justice that basically says because 300 inquiries were made, the records of every single American became relevant.
And a unanimous consent request will be considered under general lead. The gentleman from Texas is...
I'm going to ask unanimous consent to revise and extend.
Without objection.
Madam Speaker, this is not about how sincere the NSA people are in implementing this technique. It is not about how careful they are. It is whether they have the right to collect the data in the first place on every phone call, on every American, every day. The Patriot Act did not specifically authorize it. Section 215 talks about tangible things that are relevant to an authorized security investigation. In NSA's interpretation of that, relevant is all data all the time. That is simply wrong. We should support the Amash Amendment and vote for it. Thank you.
Gentleman's time.
4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Those who choose to trade liberty for security will find they have neither. I yield back.
The gentleman's time has expired. The gentleman from Michigan. The gentleman from Texas is recognized.
Warrants need to be particular and specific about the place to be searched and the items to be seized. No judge would ever sign a general search warrant like the British did, allowing the police to search every house on the block, much less seize everybody's phone records. But this is what has happened under Section 15 under the government. Government's gone too far in the name of security that the Fourth Amendment has been bruised. Rein in government invasion, no more dragnet operations, get a specific warrant based on probable cause, or stay out of our lives. And that's the way it is.
The gentleman's time has expired. The gentleman from Michigan is recognized.
I yield 30 seconds to the gentleman
For misusing Section 215 to engage in the dragnet collection of all of our personal telephone records. Congress did not grant the executive the authority to collect everything it wants so long as it limits any subsequent search of that data. This amendment restores the requirement that records sought are relevant to an authorized foreign intelligence or terrorist investigation. It restores the minimal relevance standard required by Congress but ignored by successive administrations. No administration should be permitted to operate above or beyond the law as they have done in this respect. And I therefore urge all of my colleagues to vote in favor of the Amash amendment.
The gentleman's time has expired. Gentleman,
Mr. Griffith.
The gentleman from Virginia is recognized for 30 seconds.
General warrants, writs of assistance, that's what we're looking at. And the founding fathers found that to be anathema. It does, what they're doing does violate the Fourth Amendment. We took an oath to uphold the Constitution, and we're supposed to rely on a secret agency that deals with a secret court, that deals with a selective secrecy committee, and members of Congress are limited to their access to the actions of that committee, but we're supposed to trust them. Folks, we've got a job to do. I yield back. We vote yes.
Ms. Gabbard.
The gentlelady from Hawaii is recognized for 30 seconds.
Thank you, Madam Chairwoman. Countless men and women from my state of Hawaii and all across the country have worn the uniform and put their lives on the line to protect our freedoms and our liberties. I cannot, in good conscience, vote to take a single dollar from the pockets of hard-working taxpayers from across the country to pay for programs which infringe on the very liberties and freedoms our troops have fought and died for. Ben Franklin said, "They who give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety.
I yield back. The gentlelady's time has expired.